Start. These appeals have been preferred by the three appellants accused, being aggrieved by the impugned judgment and order dated 31/7/2018, passed by the High Court of Judicature at Allahabad in Criminal Appeal Numbers 2095 of 1998 and Criminal Appeal Number 2177 of 1998. Stop. The High Court dismissed the aforesaid appeals, and confirmed the judgment and order dated 28/9/1998 in Sessions Trial Number 10/96 passed by the Second Additional Sessions Judge, Jalaun at Orai, by which, the accused appellants were convicted for the offence under Section 302 of the Indian Penal Code 1860 (bracket open for short), the IPC (bracket out) against Atar Singh, Shivpal Singh and Keshbhan Singh, and have been sentenced to undergo life imprisonment. Stop. They have also been convicted under Section 302 read with Section 34 of IPC. Stop para. We have heard Sri Divyesh Pratap Singh, learned counsel, appearing for the appellants, and Sri Dhirendra Singh Parmar, learned counsel, appearing for the respondent-State. We have perused the material on record as well as the original record. Stop para. Learned counsel for the appellants at the outset contended that the post-mortem reports at exhibits K2, K12 and K22 do not have the FIR number on them. Stop. In fact, there was no FIR registered until the post-mortem was conducted on the dead bodies. Stop. Initially, the case was registered only against Jaswant Singh, who is not the accused at all. Stop. It was next contended that there is inconsistency in the testimony of PW1 and PW2, who are examined as the eyewitnesses by the prosecution. Stop. Also, the complainant PW1 has tried to make improvements in the case of prosecution. Stop. It was contended that the impugned judgment of the High Court and that of the Sessions Court may be set aside and the accused may be acquitted of all the charges against them. Stop para. Learned counsel for the appellant placed reliance on three judgments of this court in the case of Parvat Singh versus the State of Madhya Pradesh in bracket 2020, 4 SCC 33, Parvat Singh, Chetram versus the State of Uttarakhand in bracket 2014, 13 SCC 105 in bracket Chetram, and Suresh and another versus the State of UP in bracket 2001, 3 SCC 673 in bracket Suresh. Stop para. This court in Parvat Singh held that there cannot be a conviction when the evidence and the deposition of the sole eyewitness was found full of material contradictions, omissions and improvements, and therefore the accused were given the benefit of doubt. Stop. Relying on the aforesaid decision, it was contended that the evidence of PW1 and PW2 stated to be the eyewitnesses is not consistent and that there are attempts made for improvement in the case of prosecution when compared to the material on record in the form of complainant's statement, etc., recorded prior to the commencement of the trial, under Section 161 CRPC. Stop para. It was contended that in the aforesaid case, it was found that there were material contradictions and improvement in the statement of the informant as well as the depositions before the court below, qua the accused therein, and that there was a prior enmity and no other independent witnesses has supported the case of the prosecution. Stop over.